Right, welcome everyone to today's webinar, Irish Landscape Institute in association with the Irish branch of the Arboricultural Association. I have great pleasure to introduce today's speaker, who's Joe McConville, and he'll be talking on the subject of trees and the law, an arborist's view. Joe is the principal and senior consultant with JM McConville Associates, Arboricultural Consultants. Practice deals with arboriculture and historic landscape management. Having qualified from the National University of Ireland with a Bachelor of Agricultural Science degree in horticulture, he qualified as a tree surgeon to the level of Craftsman, examined and certified with distinctions by the City of Guilds of London Institute. He is a member of the Arboricultural Association and an associate member of the Landscape Institute Management and a Chartered Environmentalist. He has considerable experience in litigation as an expert witness over his 40 years in practice. Before I hand over to Joe, can I remind everyone who wants to receive CPD points to make sure that their name is displayed on their screen, please? So over to you, Joe.
Thank you very much, Mark, and it's great to be able to talk to you here this afternoon. So just a thought process before we start, and that's the earliest law for mankind was concerned with trees, and as you probably all remember from your school days, it's from Genesis. So you're free to eat from any tree in the garden, but the tree of knowledge of good and evil you are not to eat. For the day you eat that, you are doomed to die. Now, we probably need more of that legislation. So what I want to just explain to you, if you don't already know, that we live in a common law jurisdiction. That is, the law that we're based our law on is common law from the Norman period. And any of the countries, about a third of the world, use the common law system. So it's a system that looks at past decisions of the courts and synthesizes the legal principles of past cases. So in some part, it can be interpretations of statute law, but a lot of the time it's deals with case law. And as I said earlier, a third of the world uses the common law system. So all of the what would have been the Commonwealth countries, the likes of Canada, Australia, New Zealand, the USA, South Africa, all of those use common law. And as far as I'm aware, having done the research, Ireland is the only country in the common law areas which has defined a tree in legislation. So that a tree is physically described. So, and it's in the Forestry Act. So a tree means any freestanding woody perennial plant whose species has the potential to more or less definite crown and be capable of reaching a minimum height of 5 meters at maturity. And it includes sapling of the species birch and hazel. And I'm not entirely sure why, when they wrote the Forestry Act, they had to specifically include birch and hazel, but they have. So that's what we're talking about when we refer to trees, that description. So I'm going to talk today about a number of pieces of legislation, and I want to sort of go through them all in some detail. So these are just coming up on the screen now, and I'm just going to run through them briefly, and then I'm going to go through each section in detail. So you could imagine a talk on trees and the law could take a very long time because there's so much of it, but I want to deal with these 4 specific issues. First one is the Forestry Act. Now, the Forestry Act was written published in 2014, but not signed into legislation until 2017. So with the Act came the Forest Regulations of 2017, and they've been amended in 2022. And then there's been a further amendment to the legislation with regards to planting, and that's the Animal Health and Welfare and Forestry Miscellaneous Provisions Act of 2022. So I'll come back to those. I want to talk to you about the Planning and Development Act, which is the sort of the backbone of the planning system, and potential changes, amendments to that, which are currently going through Parliament, which is the Urban Tree Protection and Sites Locally Important for Ecology Bill 2023. The third thing I want to talk to you today about is generally the Wildlife Acts from 1976 to 2012, how they impact on our tree management. And they're very much then, the Wildlife Acts are incorporated and amended by the Roads Act and more recently the Heritage Act. And I'll come back to all of that. And the last thing I want to talk to you about is an understanding of the rights and privileges that neighbours have with each other concerning their boundary properties and boundary trees. And the legislation that pertains to that is the Land Conveyancing Law Reform Act of 2009. So to begin, one of the big issues, there's an unintended consequence in the Forestry Act, which was sort of slipped under the radar for a while. But what you may or may not be aware of is that in addition to requiring a felling license, you now require a license to plant trees. Now, you can plant an area which is less than 0.1 of a hectare. So if the land that you want to plant up is less than 0.1 of a hectare, so that's an area of about 31.62, 32 meters by 32 meters, or in old money, 103 feet by 103 feet. Now, that's a sufficient area to encompass a single large veteran of mature oak tree. They'll often fill that size. So the next level of where the exemptions come in for not needing a license or needing a planting license is that the canopy cover of the area cannot exceed 20% of the total area at maturity, not at planting now, but at maturity. So if you plant 2 oak trees, in theory, in time, they will have a crown spread of easily 30 by 30 meters. So technically, you probably need a license to do that. Now, there was an amendment to the licensing, and that allowed to plant up to 1 hectare, an area of 1 hectare, but not wider than 20 meters with native trees. So this provision came from the Animal Health and Welfare and Forestry Miscellaneous Provisions Act of 2022, and in particular, Section 9, which allows the planting of up to 1 hectare of native trees without a license. Now, that does not mean that there's a free-for-all that you can go out tomorrow and plant that area up. You must apply for the grant. It's a grant-aided scheme. You can apply for the grant. You might not get the grant. You may not draw down the grant, but you can only have the exemption if you go into the system and apply for the grant, put in the grant application. And the list of native trees that you can plant are at the back of that piece of legislation. And they are all of the ordinary native trees that we would understand as being native, but they do include some strange plants like our native English white beam, which is a sort of a small shrubby bush, and rock white beam, which is also a very small shrub, which doesn't really grow over 2 meters, which kind of makes a joke of the fact that a tree is defined as any plant that can grow up to 5 meters. But they've then put a bush in, which we know doesn't grow up to 2 meters. So there's a bit of an anomaly there. The other thing that you cannot do if you're planting up this 1 hectare of native trees, you cannot use more than 25% Scots pine. So this does not allow you plant pine wood. So that's the situation as it stands at the moment with planting licensing. Now, sorry, just go back for a second. The fine for planting without a license is €500,000. So before this piece of amending legislation was brought in 2022, through the people I work with, we put a parliamentary question to Pippa Hackett, who is the Minister in charge of Forestry. And we asked her, she is an elected member to the Senate rather than to the Dáil, but we asked her how many licenses had been applied for to plant trees. And the answer came back was 0. And then we asked how many people had been prosecuted for planting trees without a license. And the answer came back as 0. So a number of organizations that I was involved with were doing tree planting schemes, planting up sides of motorways, doing, urban planting schemes, and they were all put on hold. So we had the idea that what we would do is we would plant less than 0.1 of a hectare and then leave a 2 meter gap and plant another block and continue planting in that manner. And that caused enormous concern to the Forest Service because they felt that wasn't the spirit of the legislation. But we got away with it, but we probably won't be doing that too much more, because I don't think anybody wants to particularly start a campaign of civil disobedience by planting trees. But it's an anomaly that's come out of the Forestry Act that probably does need to be dealt with. And I'm sure many of you as practitioners are struggling with the whole concept of needing a felling license. And when you read the new Forestry Act, there's quite a number of exemptions, but some of them seem to be contradictory. The basic principle was that planning and trees related to planning would be dealt with by the planning authorities, and that the retention or removal of the trees would be dealt with in the planning applications, rather than getting planning permission and then having to revert back to the Department of Agriculture to get a felling license. So their plan was to sort of disengage from the control of tree removal in areas subject to planning. Within the the Forestry Act, they refer to urban areas, and I think this is a difficult misunderstanding in legislation. You've got to go crawl back through the legislation to about 2000, where an urban area is defined, and what it basically means is it's before the reform of the local authorities, and any area that heretofore was governed by a town council, a borough council, or a city council were then considered to be urban areas. So to give you an example, in the past, Bray had its own town council. So there was Bray, and then there was urban district councils. So in Bray, there was an urban district council. The urban district councils, the town councils, the borough councils, and some of the city councils have been abolished, and they've all been rolled into county councils. So Wicklow County Council now manage Bray, but for the purposes of the Forestry Act and for felling, the area previously governed by the Bray Urban District Council is now legally referred to as an urban area. So Bray is an urban area. Dún Laoghaire is not an urban area, because Dún Laoghaire Town Council was abolished before the change in this legislation. Dublin City is an urban area. Parts of Drogheda are an urban area, the likes of Kilkenny. But big chunks of Fingal, South Dublin, and Dún Laoghaire Rathdown are not urban areas. And that's something that people don't fully understand. So they are subject to felling licenses, unless there are other exemptions, such proximity to housing. But that's something that kind of slips through the net. If, for example, you're dealing with a planning application and you get your planning application and your trees are shown on the application to be removed, then no felling license is required, even though you might be in Dún Laoghaire Rathdown and not in an urban area. So the planning system deals with it. But for an ordinary situation where you just want to take a tree down, it is very likely in some areas that you may have needed a felling license, even though it's a built-up area. But if it's not within 30 meters of a tree, it's not exempt. So that's just something to cover that on the Forestry Act and its nuances. So what I want to talk to you next about is the Planning and Development Act of 2000, which covers tree preservation orders. So in January 2002, the section of the Planning and Development Act 2000, which is section 205, which deals with tree preservation orders, was enacted. So it was brought into being 2 years after the initial act. And what it did was it made all existing tree preservation orders subject to the provisions of the new legislation. So all of the 1963 preservation orders were now deemed to have been made on the 21st of January 2002. Tree preservation orders continue indefinitely with no obligation to review them. So there's nothing in the legislation that requires the county councils or the town councils, city councils rather, to amend or review these preservation orders once they're made. And activities to be prohibited remain from the old legislation, i.e. the damage to roots and branches, and so the trees are protected. within the new legislation, there are new provisions of financial assistance available for the management of these protected trees. That has been a stumbling block for some local authorities. When they read this, it really puts them off getting involved because they feel they may have to financially fund and manage these trees on private property into the future. And that has been a stumbling block, one of the stumbling blocks for them not being used. So the mechanism for making a tree preservation order, it rests with either the planning officer, who then will issue a notice of intention served on the landowner and give an opportunity for observations and submissions. At that point, then, it is handed over to the elected members of the local authority to either confirm or revoke the order. So a planning officer or a tree officer or a park superintendent can make a recommendation to the county manager, who can then sign an order, but the order has to be dealt with and confirmed by the elected members. It's the elected members that have the absolute power at the end of the day. Elected members can also make a tree preservation order, and this has happened contrary to the wishes of the county manager or the parks department or anybody else in the local authority. So there is a case of elected members making TPOs without really referring to the technical staff in the local authority. Now, the difficulty is that there's no procedure for evaluating any submissions or objections on the TPO notice. So once the tree preservation order, a decision is made to make an order, the order is drawn up. There's no guidance on what should be in the order. There's no template. And then you have this opportunity to make submissions or objections within the normal 4 weeks, or 6 weeks, I think it is in this case. But once those submissions and objections are handed in, nobody is going to evaluate them. There's no mechanism or procedure as to who's going to read them and make a decision as to whether they're reasonable or not. It's because it's been directed by the elected members. And this is where we have a major problem, because of an historic twist of fate. So under the Good Friday Agreement, or the Belfast Agreement, both the British and Irish governments had to enact the European Convention on Human Rights into their local legislation. And this had really, for obvious reasons, had to do with the situation of human rights during the Troubles. So as part of the agreement, both jurisdictions brought the Human Rights Convention. And in Ireland, it was the European Convention on Human Rights Act of 2003. Now, the difficulty with that is in part of that, in Article 6 of the European Convention on Human Rights, it says in determination of his civil rights and obligations, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Now, this prior to 2002 would have been Bord Pleanála. But under the new legislation, there is no appeal system to Bord Pleanála. So once a tree preservation order is made, there is no way of appealing it. The only option that's open to people is to go and take a judicial review. Now, these are expensive and complicated, but the problem that has arisen is that the order is a provisional order, and there's no requirement in the legislation for that order to be confirmed by the local authority. In Northern Ireland, which the legislation is basically a copy of, there's a period of 6 months. And if the local authority do not confirm the order within 6 months, the order is deemed to be null and void. In the Republic, there is no time frame for confirming the order. And I'm aware of a preservation order that was made in February of 2002, which is now 22 years ago, which has never been confirmed, but it has all the rights and privileges and protections of a protection order. So you can go for a judicial review, but what is happening is that the orders that are coming out are marked proposed preservation order. And landowners and their solicitors are thinking, okay, well, when this is confirmed, then we'll go for judicial review, when a decision is made about this. But that's where they make a mistake. The decision is made on the provisional order, and you've got 6 weeks to make a judicial review. And what's happening is people are going, well, we haven't really had the order confirmed. It's just a provision. It's you know, it's not fully, but in fact it is. So there is no proper system of appeal. So what the legislation, the Human Rights Act, allows is, in interpreting and applying any statutory provision or rule of law, a court shall, insofar as it is possible, subject to the rules of law relating to such interpretation and application, to do so in a manner compatible with the state's obligation under the convention provisions. So because a landowner cannot appeal his private preservation order, it is now, so making an order is now, it hasn't been tested, so I'm only giving the legal opinion I've got from senior counsel. It is likely that any order is in breach of the European Convention on Human Rights, in which case, if someone takes a case, the case that they take will overturn the TPO and will overturn all TPOs currently on the statute, on the books in local authorities. And this is something that really does need to be dealt with. Another problem is that it remains an offence to contravene a proposed order. So once a notice is served, there's no need to ever confirm it. The order has the backing and protection of the law. 1.27 million is the fine, and a conviction and a criminal record. So why would you bother confirming it? Felling or pruning trees to facilitate development requires the TPO to be revoked or amended. And this requires the full procedure, a notice, and the elected members of the local authority to vote on it. So unlike in Northern Ireland or in England and Wales, there isn't a system of works orders where you can go and prune a tree or maybe take a tree down that's agreed by the planning authority. The whole system has to rerun from the beginning. So if you've got 12 trees in your order, and you want to take one of them down, and it's all agreed, then you've got to amend and revoke the order, and that the new order now has 11 trees. So it's a very cumbersome system because there's no regulations and no guidelines. And then under the old legislation, certain statutory bodies can prune and fell the tree. So in the legislation, it talks about dead, dying, or dangerous. But the difficulty is, in whose opinion is a tree dead, dying, or dangerous? You may be aware that there was a case taken in the UK on the basis, it was taken on the basis of philosophy that everything is dying from the time it's born. So by that fact, everything is dying. Entropy is kicking in. So therefore all TPO trees are dying, and of course that was thrown out. The word dangerous probably should stay, but the word dead trees are not necessarily a bad thing. And it's commonplace on some properties to retain dead trees for habitat. So you could protect a dead oak for a rare beetle. So dead isn't a great thing, dying isn't a great thing, but dangerous then. But in whose opinion is it dangerous? And then what happens after it's been cut down? Who can then prove it was or wasn't dangerous? The current preservation orders do not restrain any work to prevent or abate a nuisance or a hazard. But again, in whose opinion? In whose opinion is the branch of the tree causing a nuisance that needs to be abated? That's not clear. So the solution is fairly straightforward. What needs to happen is there needs to be guidelines and to some extent regulations. Now, I've met with the Department of the Environment, and they've made it very clear that under the current legislation, the current act, there is no provision in that legislation to allow for the creation of regulations. So I've been told that's not going to happen. And the guidelines that are attached to the department's website are the 1993 guidelines, which pertain to the 63 Act, and they've just had the date and page taken off the front cover. And all of the guidelines are related to a piece of legislation that has been appealed and doesn't exist anymore. We need to have the guidelines to vary TPOs or revoke them as appropriately. have applications to carry out work, and make it simple to modify or revoke, and to provide consents to do work to TPO trees. Now, I've been personally drawing attention to this issue with members of Dáil Éireann for a number of years, not making much progress, but more recently, in a conversation with the Green Party, they decided to have a go, and what is currently going through the Parliament is the Urban Tree Protection and Sites of Local Importance for Ecology Bill 2023. This has got through its first stage. It's a private members bill by the Green Party, so it's not high up on the agenda, and it's a bit of a lottery as to whether it gets selected to go forward to the next reading. But basically, the plan there is to insert, a person may apply to the planning authority to ask it to consider making, amending, or revoking an order under this section. So that means that the public can get involved. Or that's the thing. And what they want to change is that the minister shall make regulations providing for an appeals process where the planning authority makes a decision regarding a tree preservation order. So if that was passed, that would remove the issue of the European Convention on Human Rights and making TPOs unconstitutional under the European Convention. So by making regulations to allow for an appeal system, that would in part fix the problem. We still have to deal with the issues of guidelines and modifying them and making them more workable. So there is a solution there, but the concern I have is that because there's probably only a year left in this Parliament, private members bill is going to get kicked to touch, and I don't think then there may not be an appetite to look at it again. What I've been told is that the sponsor of this private members bill is tabling similar pieces of legislation to be amended into the current Planning and Development Act, which is being reviewed. But again, that may or may not happen. It may not get any traction. So that's the kind of the issues with the Planning Act and the dysfunctional TPOs. And the end result of that, I suppose, is that there is no proper system of protecting trees. And as you probably are aware, there is occasionally situations where sites are being cleared before planning permissions are, the planning system is engaged. So the sites are sort of pre-prepped so that trees don't become an issue. I was at a planning inquiry whereby the intention was to substantially remove all of the trees from the site, which has happened. And I was acting for the local residents, and we pointed out at the board appeal that there was an objective in the county development plan to protect and preserve woodlands on the site. And it was made very clear by the local authority and by the board's reaction. And what the local authority pointed out to us was that this is not a legal status. It is an aid memoir. And that the fact that there's a star or a tree symbol on a county development plan, it's only an aspiration, and it has no legal basis. So it's not an enforceable objective. So if the developer wants to override it and remove the trees, he can. Under the previous legislation, the 63 Act, to make a TPO, the local authority had to identify the trees, and there had to be an objective in their county development plan for a TPO to follow through. But now we've neither functioning TPOs or a proper system of designating land use. So that needs to be addressed. The Wildlife Acts are something that I suppose everybody has some understanding of, and is engaged with, and would very much know that as of tomorrow, there's going to be a restriction on cutting trees. Now, the Wildlife Act starts in 1976, and it sets out the principle that you want to avoid removing vegetation, destroying, burning vegetation on uncultivated land during the nesting season, and that's a laudable and proper thing to do. The dates get changed in the later versions of the Act, But the plan was that the unintentional damage would not be liable to prosecution under the Wildlife Act. So somebody did something without intention or malice or forethought, that they wouldn't be looked at as quite as bad an option as against somebody that deliberately pulled out habitats. So species or habitats in the list of the Habitats Directive must be conserved. So it's important that there's protections here. However, there are a number of exemptions of which construction and agriculture can be exempt. So, which is a practical solution. So the development of roads, bridges, and sites for housing is not covered by this legislation. So it is not an offence to remove, destroy vegetation after the 1st of March, if the purpose of that is to build houses, roads, bridges, or engineering works. Now, that's not really very well understood, because if there's another section of the Wildlife Act that protects species, and in the amending legislation over the years, all birds are now protected. There was a time where not all birds were protected, so the likes of wood pigeons and crows were not protected, but every single bird is a protected species now. So if you've got birds actively nesting in your trees or hedgerows, your exemption while carrying out construction is removed, because it's still an offence to damage the breeding or resting place of a protected animal, i.e. the birds. And the same thing applies with agricultural activities. I was involved in a prosecution where the farmer had removed a load of willow from a ditch, which was blocking the ditch, the ditch was actually an 18th century ha-ha, and it was protecting a lime avenue from the farmland. But over the years, it had filled up with willow and had become overgrown and blocked. And he went in June when the ground was nice and hard, and he pulled out the ditch, and he was prosecuted. Now, he was prosecuted under the destruction of vegetation. As it happened, the wildlife officer did do a detailed assessment of the damage and found no nests. So there was no birds nesting in these willows. There was no active nests, there was no old nests, and there were no birds. So he hadn't committed an offence under the destruction of a protected species. But in the prosecution, the wildlife officer suggested to the court that there was a quantum that you could remove under this exemption, and that the view was that this exemption would allow you prune back a tree that landed on an electric fence, or that you could open up a gap to get a combine harvester in, but it didn't allow for the whole-scale removal of a hedge during the period, where in actual fact the courts decided that it did allow. The exemption stood because there's nothing in the Wildlife Act that talks about quantum. So the prosecution failed. But the issue is, if people had been on the ball, it wasn't my job, but he should have been prosecuted under the Forestry Act, because in the Forestry Act there is a quantum where you can only remove 3 cubic meters of trees without getting a license. And if he applied for a license, the license probably, to be on the safe side, would have restricted the removal of the trees to an appropriate period in the year. So what you've got to do is you've got to look and join up all these pieces of legislation to better understand them. Now, an issue has arisen with local authorities over the last number of years, where during the summer, roadside hedges and bushes and trees kind of will grow out into the carriageway, block signs, and make it very difficult, for road management. And the general response that is given back from the local authorities to say, oh no, there's a restriction to the pruning of hedgerows during the nesting period. Well, in actual fact, this is not true, because in the Heritage Act 2018, the Wildlife Act was amended, and it allows the felling, cutting, lopping, trimming, or removal of trees and shrubs or hedges or other vegetation pursuant to Section 70 of the Roads Act. And in simple terms, Section 70 of the Roads Act provides for landowners and local authorities to manage the roadside trees to ensure that nothing close to the road is a hazard or potential hazard to the road users. So this has been here since 2018, so we're a while in it, but it's not been dealt with because I don't think people really know about it. And one of the things I would say, and the difficulties that we have, is if you pick up a piece of legislation such as the Wildlife Acts and read them in without fully knowing that they've been amended up and down up until 2018, you may not get the full picture of what's involved and what's required and what you can and can't do. So it is important to understand that the blanket ban on the destruction of vegetation during the period the 1st of March to the 31st of August has a number of significant exemptions. Agriculture, horticulture, obviously, because horticulture is defined as being a part of agriculture, as is forestry. Because if you think about this, it would be no forestry activities could take place after tomorrow. So the whole forest industry would shut down. There'd be no felling, there'd be no processing if these exemptions didn't exist, but they do. What you have to remember, what's really, really important, is that the other sections of the Wildlife Acts protect species. So if you've got a protected species in the woods or in the trees, then you cannot destroy their habitat. Now, under the this new piece of legislation, which is the Urban Tree Protection and Sites of Local Importance for Ecology, there is a proposal in that bill to amend Section 70 of the Roads Act, which deals with the duty of care of landowners, and whereby if the plants, the trees, are a potential hazard to the roadside, where they want to add in the words "as a last resort," so that felling isn't the go-to solution to deal with the hazard problem. And I think probably that's not a bad thing if it can be managed, you know, so that we don't automatically think when somebody gets a Section 70, also known as dangerous tree notices, that they have to fell all the trees. It may well be that there are certain branches that need to be dealt with. And that's kind of the type of work that we would do as arborists, that we'd advise people. And in some instances, we have gone and advised local authorities that the requirement to fell the trees isn't necessary, and some pruning works would make the trees safer and therefore comply with the Section 70. So that may be, again, if this bill gets legs, that might be a good thing as well. But again, if it does, it's going to be in this legislation, and the Roads Act will still read the same, so people may not be aware of the change. So the last thing that I want to talk to you about today, for about 5 or 10 minutes, and then we'll have a bit of an opportunity if there's anybody that has any questions or things that I have sort of started but haven't been very clear about, is how do we deal with neighbors' trees? It's often a situation where people will plant trees along boundaries in houses, and then they become problematic to the people living in the houses, into the neighbors' properties. Or you might get a situation where, which is actually something that I was approached about yesterday, where as towns move out into the countryside, there'll be a sort of a fringe where housing estates are backing onto or you know, up to agricultural land. And the agricultural land may well have an agricultural field boundary. So that field hasn't been sold, or is potential development land which hasn't been developed. And then the houses are built, and now the neighbours have to deal with what they perceive to be large, unruly trees overhanging their gardens. So this goes back to what I said at the beginning of the talk, where that Ireland is part of the common law area, and so therefore any precedents that go through the courts where judgments are made and decisions are made can be used in this jurisdiction. And the best and most well-known piece of legislation is the case of Lemon versus Webb, which I've badly written the reference there, but it was originally heard in 1894, and then published in the 1890 journals in 1895, 1894. And what this really sets out is whether or not a neighbour can cut back branches that are overhanging or roots that are encroaching across the boundary. And there's a whole load of supplementary legislation and case law in that sort of backs up this, that says, yeah, so, it's encroachment, it's creating a nuisance, you can abate the nuisance, so you can, if you want, prune back. And then there's issues of who owns the branches, whether or not if the branch comes over into your airspace, you don't own it, so you can cut it, but you've got to give it back. Or if there's fruit, who owns the fruit? And all these things were sort of worked out in the courts. I have to say, in my 40-year career, I was of the opinion, and I believed it to be the case, because I'm pretty sure when I was at college in England that someone read out this piece of Victorian case law, and my memory was that it said that you could prune back to the boundary providing you didn't commit riot. And we always understood that to mean that you could cut back to the boundary providing that you didn't do damage to the trees or cause the trees to become unstable or in some way, damage the property. In the recent years, the courts here, the judges here, have been very, very clear that you are completely and utterly entitled to cut back to the boundary and no further. And that includes roots. You can imagine that when this case law happened in 1890s, there was no such thing as cherry pickers or MUPs, mechanically elevated work platforms. So you really weren't going to do a whole load of damage pruning back your neighbor's trees. But now you can bring into your property a 120-foot mobile elevated work platform, and you can do serious damage to your trees. And you can leave them in such a way that, as has happened in cases I've been involved in, where they've become unstable. But it's very clear from the case law is that neighbours are perfectly entitled to do that, providing they do not go over the boundary. And if they go across the boundary, then they are committing trespass. And that then is deemed to be an offence under the Criminal Damages Act of 1991. Now, unfortunately, the guards have absolutely no appetite for getting involved. And if your neighbour is cutting your trees and you ring the guards, I can almost guarantee you they will come out and say, it's a civil matter, we're not interested. And I had one guard say to me, it is above my pay grade. So they won't really engage with you. And it's a very rare occasion where these things happen, that a prosecution arises. I have been aware of a few, and they've usually ended up with the offending neighbour being cautioned. Rarely have I ever heard of anyone being prosecuted under the Criminal Damages Act. And what's interesting is it's a very similar piece of legislation to that in England and Wales. But in England and Wales, trees are specifically removed from that legislation. Whereas in the Republic, the Criminal Damage Act specifically refers to vegetation and trees. So that's something that you could take your neighbour to court if you thought he had done damage. And this usually happens, unfortunately, when you go on holidays, you come back, your trees are gone. And now you've no actual way of proving anybody. You can't prove who did it. And we've had cases where everybody knows who did it, but nobody will tell anybody. So that there's nothing anyone can do, because you don't have to incriminate yourself. So if the DPP, the prosecution service, can't prove you cut the trees, you can keep your mouth shut, and it's going to be very difficult to prove who cut them. A number of years ago, there was a lot of talk in England and Wales and Scotland about the difficulty caused by high hedges, particularly leyland cypress. They became very problematic, particularly in smaller gardens. People planted them as hedges. They grew out of control. The people that planted them couldn't really manage them. They became very expensive, and they just left them. They grew, and they became a real problem. At the time the legislation was going to go through, there was a high hedges bill, and it was dropped. And how they dealt with it in England and Wales was they put in a system of they covered it under antisocial behaviour orders. So if you were being particularly difficult neighbour, your neighbour could get an antisocial behaviour order out against you to do something about the tree. But in Northern Ireland, they went the full way, and there is the High Hedges Act, And it's a very, very good piece of legislation. It's complex. It explains how you do the assessments. It gives you all the formulas to work out all the systems. The guidelines were written for the England and Wales for the legislation that was never enacted, but those guidelines are used to work with the Northern Ireland Act. Now, in the Republic, there was no appetite for dealing with a high hedges legislation, because at the end of the day, it was going to be the local authorities that were going to have to be the adjudicators, and none of the local authorities had any appetite for sending their staff out to get involved in neighbourly disputes. So what's happened here is, quietly and under the radar, there's a piece of legislation that was published in 2009, which is the Land and Conveyancing Law Reform Act. And this basically means, and it relates to all issues with neighbours. So if your neighbour is refusing to manage or control trees on a boundary, a works order can be sought from the district court. And that's an enforceable piece of legislation then, that they have to go and do that work. I am aware of one case where the situation with the leyland hedge went on for so long, and it became such an issue for the aggrieved neighbour, that the judge awarded the aggrieved neighbour €63,000 in damages, as well as the court order. But that would have been a rare situation. So it's Section 45 of the Law Reform Act, as it shortens to, which says a building owner who is in dispute with an adjoining owner with respect to exercising the rights under may apply to the court for an order or authorizing the carrying out of specified works, and that's the works order. And specifically then in that legislation, the party structure or the boundary between the two properties has been defined as any arch, ceiling, ditch, floor, fence, and the important bit here is hedge, shrub, tree, or other structure which horizontally, vertically, or in other way divides or separates owned buildings. And then the really important part of this is situated at or so close to the boundary line between adjoining and separately owned buildings, or between such buildings and unbuilt lands, that it's impossible or not reasonable to practically carry out the works to the structure without accessing the adjoining building or unbuilt land. So from a tree's point of view, the trees really have to be on the boundary. We had a case where the tree was set back a number of meters, and it was thrown out. It was deemed that the piece of legislation that they were looking to get the works order wasn't appropriate for that situation, and that what the judge recommended is that the aggrieved party would take a civil action for a breach of a hazard or a nuisance, and seek relief from the courts to have the nuisance abated. So that's the last, that's what you could do then, is you could go to the court, the High Court generally, to have your neighbour abate the nuisance. That becomes complicated and expensive. With the district court order, in theory, you wouldn't need a solicitor. Be recommended, but you could, in theory, apply to the court register yourself for a hearing and provide the information. So it shouldn't be an expensive system of accessing a court order to deal with unruly neighbours. So I think that's as much as I want to say. I wanted to leave about 10 minutes. If anybody had any questions, if I can answer them, I'd be very happy to. So thank you very much for listening.
Thanks very much, Joe. You might want to get a glass of water there before you launch into the questions. I can do a bit of publicity.
I'll do that for 2 seconds.
Yeah, so just to remind members that if you want to get assigned your CPD points for attending, to make sure you have your name printed on your screen. Also, I'd like to draw attention to our next webinar, which will be held on the 29th of March. And it's going to be given by Dr. Melinda Lyons, who will be talking on the subject of nature conservation and the biodiversity crisis. So that's the 28th of March, sorry, from 1 p.m. to 2 p.m. The exact content of the talk will be on ironed out a little bit closer to time, but Melinda's a very excellent speaker, so I can highly recommend that one. I'd like to draw attention to the opportunities to join the Irish Landscape Institute as well. So you can check it out on our website under the membership tab. So for people who aren't landscape architects, there are memberships that can be taken out, such as the affiliate membership. So Joe, if you're ready for questions, then
Yeah,
I'm going to go in with a couple on TPOs. So the first one is from David Hackett, which is, does that mean that a 1960 blanket TPO now requires local authority approval for pruning, etc.? Or in this case, is it still the Department of Agriculture and Forestry?
No, so a blanket TPO, which was very common, would be basically if you wanted to do any pruning to any of the trees, you would have to get the TPO amended, which would require a full advertisement in the paper, a site notice, a notification, and then approval by the elected members of that authority.
So that's what's required to prune the trees covered under that blanket TPO.
Unless the tree was dead, dying or diseased, dangerous, or the pruning was required to abate a nuisance. Now, in general terms, abating a nuisance is removing something, but under the TPO legislation, the nuisance that's being abated has to be something that would be successful as an action in a court case. So it can't be frivolous. It has to be something that's rubbing against a building, damaging property, whatever. Yeah. So that would be for the blanket TPO.
Right. So then next question is from Sinead. If TPOs are not mentioned in a local development plan, does that mean they are null and void?
No, any TPO that's been made, there should be a registrar somewhere, a registry somewhere of all the TPOs that have been made, and they stand permanently there forever. They don't fall away. They don't run out. There's no timeline. They don't disappear. They don't have to actually be mentioned. They could be just sitting there and no one might know about them. But if they exist, they stay forever.
Okay. And a question for myself then, just from your talk, is there a difference in the effectiveness of TPOs depending on when they were made?
No, all TPOs are deemed to have been made on the 21st of January 2002 under the current legislation.
Right.
So they're all broken. So even though the ones that came before that worked perfectly well, the systems that allowed us manage with those have been taken away from us.
They're all broken, but if you were to be in breach of one, you're leaving yourself liable to severe punishment. Is that correct?
1.27 million.
Yeah. Question then from Tim Thomas. I'm under the impression there is less than a dozen TPOs in the whole country. Is that true?
No, Wicklow has a vast number of them. There are 2 in Dublin. There is about, I'm going to say 7 or 8 in Dún Laoghaire, a couple more in Fingal. There are quite a number of them. They are scattered across the whole country. There would be a lot of them, but they tend to be on the older side of them. There's very few modern ones that aren't problematic. But no, there's a lot of TPOs across the country.
So a question then from Paula Carney, which is under the 2023 bill, do you know what constitutes sites locally important for ecology, i.e. sites identified in the development plan or designated by other legislation?
I think I deliberately didn't do this to explain that today, but what I would recommend to that questioner is to just go onto the website and put in that bill. The whole bill will come up and you can specifically read the criteria for what's deemed to be a locally important ecology. As you would know, as landscape architects and managers, that there is a move now for green infrastructure planning. South Dublin are sort of at the forefront of green infrastructure plans, and that's all got to do with locally important ecology. So I would recommend that they just pull up the bill and have a read of what the definitions of locally significant ecological sites are. It's very self-explanatory. I just deliberately didn't cover it. I didn't have enough time today.
And that bill is not in force yet, is that correct?
No, it's only at second. It's only got past the first stage, so it has to go through second stage reading, and there's many more, and then into the Senate. But it's a private members bill, so it might not get a second hearing in this term. So it's on thin ice, I think. But it seems like a nice piece of legislation.
Thanks. So a question then from Oisin Slater. Are there any cases of prosecutions for cutting trees down during the nesting season?
Yes, they are. If it happens all the time, particularly when the cutting is active and people ring up the officers and people come out and you're caught red-handed. Yeah, it does. People are prosecuted. Yes, and it is an offence to destroy the nesting place or the resting place of a protected species, and that very much includes bats when we talk about trees. Bats are one of the most vulnerable species, protected species, when it comes to trees and tree removal during that period. So we'd always recommend, if you are going to use the exemption, that you get an expert, a bat expert in, or a zoologist to make sure that you do not have any nests or roosts or resting places before you do anything. Yeah.
Question then from Barry McKenna, and Barry, you might want to come in there if I get this wrong, because I think this is in the context of an exemption during the nesting season. So the question is, can you clarify that tree works can still be undertaken where there is clear visibility of and around a tree, or completion of a nesting birds form checklist would, however, be advisable?
If you're carrying out the works to facilitate construction or development, or if you're carrying out the works under normal agricultural practices and you can prove that there are no, or forestry activity, and you can prove that there are no nests, active nests, then the exemption. But as a general rule, if you're not building, if it's not destruction of vegetation for construction or agriculture, then the exemption, there is no exemption.
So a query then from Owen Keane regarding the legality of tree removal during nesting season where the tree is demonstrably dead or in severe decline, e.g. ash dieback, severe symptoms apparent.
Again, you would, the protected species are have the rights. Ash dieback doesn't appear in April. It's, well, if you've got a tree with ash dieback, you know about it. So it's up to you, if you're managing lands, to get it done before today. That's why there's an open season for doing these things. So it's not an excuse to say, I was too busy, I have to do it in June. Because if a tree has got to that state, then yeah, and it's probably more likely to have bats and other, it will have a limited habitat value for nesting birds if it's very dead. But you can't just say, oh, it's dead. You should be doing something about it. You have a duty of care under the Occupiers Liability Act, which I didn't talk about, not to have dangerous trees. So yeah, I think the best thing is to apply the law. If there's nests, active nests, they're protected.
And would that be the case even if it's beside a road?
Again, if it's beside a road, you get into an issue. There has been situations where derogations have been sought to not comply with the habitat directives and the wildlife acts, and these derogations have been given out. But whether they're legal or not is debatable. I think it's about planning in advance and being aware of what your tree population is, and scheduling works and not leaving everything to the last minute.
Very interesting. Another question from Owen Keane. So pruning trees during the nesting season, proper arboricultural pruning, e.g. reduction according to BS 3998. Any tree types? I think that's a piece of advice there, Owen.
Again, like, you just you can't interfere with nests. So if the trees have nests in them, you can't prune them during the restricted period.
Yes. or
It's that
roosts,
simple.
or
Roosts, and you should check for bats as well. I mean, that should be a go-to before you do any work if you think your tree is a potential bat roost.
and Joe, if I suppose it's more a question for the autumn maybe, but if protected species are using the tree for forage, would that also mean that you couldn't interfere?
What you mean? Like something like, well, you could have issues with red squirrels, you know?
Yeah.
So if you've got a population of red squirrels using your trees, that's going to be their resting place. So what you're considering is resting or breeding. So if the protected species are using the trees to rest in or breed in, then they have to be respected and looked after.
I suppose nearly all hedgerows in that case would have birds resting in them during the summer.
Which is why we need, and so the only exemption then is that if the trees are dangerous and need to be managed under the Roads Act, then you've got to do a bird survey and make sure that the cutting that you do doesn't interfere with them. So it might be just minimal amount of work done to make the situation safe, but not so much that would damage the protected species, which have, you know, and we should be considering mammals as well, hedgehogs and all of that stuff. You know, so it's not straightforward. I mean, the big protection is really the protected species, but the exemptions apply to the destruction of vegetation. So you know there is a restriction, and you've got to make sure that you're complying with that restriction.
Yeah. So question then from Kevin Keary. What will the introduction of the Nature Restoration Regulations, Article 6, which involves urban green spaces, mean for the management of trees and urban forests? That's a fairly recent piece of legislation, so you mightn't be up.
No, I mean it's a huge question. I mean I'll throw that question back out wider. I'd like to know what that piece of new directive means for forestry. Yeah. I think it's the death knell to forestry, because our standard forestry, Sitka spruce, Norway spruce, you know, if we want 20% of our land cover to be biodiverse, it's really going to make planting forestry where we're not planting, and like the forest program has collapsed, and we're way behind our targets. And now if 20% of the land and 30% and 40% has to be for for restoration, then I can see the forest industry collapsing in this country because of that new legislation. That's a personal opinion, because I haven't read it all. It's only so new, but I mean, there's a lot of sense to it. We do need a lot of restoration, but you know, what are we restoring it to? You know, most of our agricultural land is man-made. It's all a construct of the Enclosures Act of the 18th century. So, you know, is monoculture woodland going to be considered not restoration? So yeah, that's a good, really important piece of legislation to watch, and how that's going to tie in with green infrastructure planning. And the other thing that's going to follow through, you can see in the United Kingdom now, they've got biodiversity net gain in planning, so that you have to have your planning applications have to have an increased biodiversity at the end. Now, that's going to be a tricky one, and that, I mean, it makes sense to follow through with, you know, the green infrastructure planning is on the same target. So, yeah, it's a good question. What does that mean?
So a question then from Chris Barnett on boundary trees. What is the legality of a tree if it crosses the neighbour's boundary due to unforeseen reasons, dying or dead without noticeable signs, wind blown during a storm, and damage is done to, say, a house? I think that question would go for any tree on somebody's property, not just a boundary.
So basically, the thing to remember is that the tree grows on the land, and whoever owns the land therefore owns the tree and is responsible for the tree. And we have the Occupiers Liability Act. So if your tree falls across your neighbor's property and damages it, you are responsible and liable.
Michael Gary is asking, can you clarify the fine for breaching TPO?
1.27 million. It was a million punts. So when we converted to euros, it became 1.27 million.
And Owen Keane and Sinead are both asking, is there a registry for TPOs?
Each county has a registry. We are trying in the Tree Council, where I represent the Arb Association at the Tree Council. We are hoping to get all of the trees councils to submit their tree TPOs into the national database in Waterford, the biodiversity database. At the moment, it will be each county will keep a register, and that can be as simple as a folder with a list in an A4 page. It's not necessarily online. Doesn't have to be, but it should be. We'll be pushing for that.
Question then from Aidan French, which I think is probably a political question rather than a legal question, but I'll throw it at you anyway. With Greens in government and with their ministers Hackett and Noonan in key departments, why is the 2023 bill a private members bill? It was introduced by Green TT Stephen Matthews. Does this indicate government apathy, lack of support by those ministers?
I tell you, I'm not going to answer a political question, but I'm going to tell you this because this is personal fact. I met the civil servants in the Department of the Environment and Local Government prior to this, and they told me very clearly and unequivocally and very, very clearly that there was no appetite in government to change the planning acts in favour of amending TPOs, and that it was not going to happen. So that's why we have a private members bill, I would suggest. But
Thanks.
that's as much as I'm going to say about that.
That's fair enough. So one from Sharon Casey. What is the grant scheme that you mentioned at the top of the talk when you mentioned the need for a license to plant trees, please?
Yeah, so there's a grant available to plant native trees once you plant over 0.1 of a hectare. It's on the Forest Service's website.
I think we've probably covered this, but it's a hot topic, so I'll ask it again. David asks, can you prune, remove trees between March and August under health and safety danger to the public? And do you have to notify any authority?
That's an excellent question. And I actually don't have the answer to that because there's so many conflicting bits of legislation that it's very difficult. So if it's a roadside tree, it's covered by the Roads Act and the amendments to the Wildlife Acts by the Heritage Act. If it's farmland, if it's construction, they're all okay. If it's general maintenance on a house, I just be cautious and make sure you've got everything written down, and and just make sure you've done an assessment to make sure there's no protected species before you know, and that you've got a record and that you're very clear about who's instructing you to do it. Because you don't want to be held, you don't want to be left holding the baby if someone comes after it. Because at the end of the day, if you're the contractor, you've pruned it, and the landowner might go, well, you never told me. So I think it's important to make sure, but it's not an easy one to answer.
Yeah. Question then: can you remove invasive species such as cherry laurel during the bird nesting season?
Again, it shouldn't be necessary to do that. That the management regime, if you can prove that there are, I mean, one of the things that I would say, and then this is quite common, rhododendron would be commonly removed from the national parks in Killarney during the summer. So you would, I think the answer would likely be yes, but you'd want to make sure that everybody knew what you were doing, and that you didn't have. It's unlikely that you'd have any significant nesting in cherry laurel, but you'd want to be careful and make sure you were covered and that it was planned.
Another one from Owen Keane: is there a short course that can be completed by tree care professionals to inform us about legality affecting our work, e.g. a day or a couple of days module of an Irish law reference tree regarding trees?
Not at the moment, but always open to looking at that with the AA. Yeah, it might be something we could look into.
Right. Now I have a few longer messages. I think one of them is bordering on tree consultancy advice, and then the other one is probably a call to arms. So I don't know. I'll throw them at you, and you can
Yeah,
addressed them or not. Let's get back to the right spot. So Alan Moore asks, our chronic group in Clonmel are trying to save 30 semi-mature London plane trees, which are all due for removal from our town centre under the terms of the 2018 Urban Design Plan for the town centre, which was passed under Part 8 process. The environmental assessment of the plan makes no assessment of the trees. The issues raised by our experience include the quality of environmental assessments and also the way in which public submissions are addressed under Part 8. There were 40 objections to the removal.
That's a difficult one, and I'll be honest with you, it's outside my area of expertise because I do very little planning consulting. I would be at the coal face doing the assessments. The sort of the ins and outs of how the Part 8s work would not be my level of expertise.
Well,
I would have thought it seems a disappointing system when no one picked up that they had a valuable resource in the centre of the town.
Yeah, the trees are still there, judging by the message. So you could probably, I don't know if Clonmel qualifies as an urban area.
It is. Clonmel would be under the remit of a historic urban area. I mean, the only thing I can suggest, and this is just a suggestion, and it's really, I mean, as I said at the beginning of the talk, it is within the gift of the elected members of an urban district council to make a TPO. So if he could get a majority of councillors on board, or then they could overturn that.
Well, yeah, it's the elected members who actually pass a Part 8 planning application, so they've already bought in. But I was going to make the same point, is that they're the ones with the power, and definitely it's to lobby your local councillors, I would say, are the ones, if public opinion, they'll roll back if there's a groundswell. But I don't think legally there's maybe anything to stop that going ahead at this point, but just
not
from the information we have there.
I'd seem to agree with you, Mark, on that. Yeah.
I mean, you could look at the requirements for environmental impact assessment under the Planning and Development Act, but they're quite. It comes down to significant impact, and what the assignment of significance is woolly, shall I say.
And they're going to be exempt because they're in Clonmel, so they're going to fall into the urban area, so they won't need a felling license. So that stretch of slowing the system down is not open to them.
So I'm going to wrap up fairly quick, but I just want to read, in part anyway, one of Aidan French's message. Aidan is campaigning on urban trees, and in particular urban forestry in general, and Aidan would like primary legislation specifically devoted to urban trees, and wants a national policy and also a bill on urban forestry, and is seeking everyone's support in getting that over the line.
Yeah. Well, I know Aidan, and he's done a lot of very good work over the years, and we really do need a proper urban tree strategy nationally, because urban trees are going to be one of the key parts of climate change mitigation, especially which is likely, we're going to have warmer summers. We're going to need a lot more tree cover. We're going to need trees in the cities and the urban areas that will function in these changed climates. So we really, and there's a lot of good work being done by landscape architects and engineers, a lot of good stuff on street tree planting in Dublin. But yeah, we definitely need to have the conversation about urban tree protection and planting and strategies really does need to be had. And I think from what Aidan's just said, we've just had another question about a situation down in Clonmel where the fabulous asset, the trees, have been ignored. So I think that's where Aidan is right. We need to have a national conversation. So anyone that's supporting that, I'd back that positive note.
That's great. Thanks so much, Joe. I'm going to leave it there because we've gone way over. It's very generous of you to give us so much information on confusing subject, I think we'll
Yeah,
agree, but
very.
we're very much enlightened now. So thanks
Okay,
very
well,
much, everyone,
thank-
and thanks to the Irish branch of the Arboricultural Association for the collaboration with the Irish Landscape Institute.